Alex, given all of these considerations you, Joel, and Awana have discussed, what can employers do to address and contain the related issues in legal exposures?
So employers are certainly going to want to take steps to assess and mitigate their risks. And a key part of that is conducting a really robust risk assessment with respect to accommodation and accommodation obligations. And in conducting a risk assessment, the same three general steps or categories of steps are going to apply as we discussed in day one in the context of health and safety risk assessments. The first one is going to be to identify accommodation-related concerns, like those that Joel, Awana, and I discussed. And the second piece is going to be to evaluate the risk that these concerns pose. Now, some of the main risks and common pitfalls that we've encountered in our practice include things like not taking accommodation requests in good faith. And another pitfall that is somewhat related is not having sufficient information to actually properly engage in the assessment of the accommodation that's needed. This is, again, closely related to another risk, which is not assessing these things on a case-by-case basis. And another pitfall that employers tend to encounter is not documenting the process fully. And you really want to be able to show that you documented everything in order to demonstrate that either you have the right accommodation or that you documented to the point of undue hardship. So this is where things like making sure you have medical letters, asking for medical limitations and prognosis information is key, and also confirming any resulting accommodation from your process in writing, as well as if you've engaged in this discourse and exercise and considered certain accommodations that you've ultimately discarded, you're going to want to document why those were not the accommodation options that were chosen. And this is related to another pitfall that we tend to see, which is employers not implementing a reasonable accommodation. And there are two different sides to this coin. The one is not having any reasonable accommodation, essentially getting it wrong, which can optically be harmful for the employer's reputation and can impact workplace morale, as well as lead to significant liability with respect to human rights and health and safety. But also not understanding that reasonable accommodation, as Joel said, is all that's needed, and you don't need to let the employee drive the bus and have their preferred or perfect accommodation. And then the last step is going to be to come up with solutions. And a good strategy for doing this is to prepare in advance and think about scenarios that you can use to plan how you're going to deal with different issues. So for example, how you're going to address mental health related work refusals, or employees refusing to do work or saying that they need an accommodation because of a physical disability, or because they have children or elderly family members at home. So you're going to want to prepare and think about the kinds of questions you may ask, the kinds of information you may need, perhaps the kinds of accommodation that you may want to implement, but you're going to have to make sure at all times that while you're using these steps to prepare, you can't shortchange the process. You can't forget that this is really a case-by-case assessment based on the circumstances of the particular request.